Y'all ready for the jurors for the rebuttal argument?
Yes, sir.
All right, let's bring in the jury. We'll continue with the rebuttal argument. Jurors entering. Jurors present in the state's rebuttal argument.
If you remember back in jury selection, all of us agreed that when we sit down as jurors in a criminal case, any criminal case, we want to view things, number one, through the lens of the jury instructions, but number two, and just as significant, we want to view them through the lens of common sense, right? We never ever check our common sense at the door in any criminal case or really in any walk of or aspect of our lives. So let's take a look and consider what counsel just said using that common sense. So they first told you that the defendant's wife killed Tanya, okay? Or at least had a role in it. Well, let's think about that for a second and let's use our common sense and use the evidence. So you might say, well, why would, first the reason is, why would she commit these killings? I mean, if you're going to kill a pregnant woman, it seems like you would have to have a pretty good reason to do that, right? You'd have to have a pretty good reason. Well, you may say, well, wait a second, well, maybe she did, maybe she found out that Tanya had slept with Jose Soto-Escalera, right? I suppose that would give her at least some motive to kill her. But if that were true, then why would Jose lie to the police about impregnating Tanya? Right? Why would he lie to the police about impregnating Tanya if she already knew that she was pregnant by her husband? That doesn't make sense. The wife did not know that the defendant had impregnated her, because if she had known, then he would have simply said that to the police when he was interviewed on August 25th of 2018, right? So that doesn't make sense. So we can rule that out, right? We can flatly rule that out, what the defense said. So then they say, well, wait a second, maybe Eric Alvarado did it, right? Maybe Eric Alvarado committed these crimes. Well, if you recall, remember, Eric Alvarado also has no motive to kill her, right? He's not the father of the child. There's no evidence that Eric Alvarado had ever had any type of relationship with Tanya, let alone sleep with her.
Ladies and gentlemen, there's an objection as to this point. There's a dispute between the lawyers. You're the finders of fact, and you get to decide which side is accurate as far as what the evidence is. So I'll overrule the objection, but leave that to the jury to sort out.
Okay. So anyway, so he had no motive to kill her, and more significant, if you recall, in the August 24th translation with Rose Rosario, what does he say? Well, Eric Alvarado asks him about the blood. Did you see blood? Did you see blood? Had Eric Alvarado been there and been involved in this, he would have had no need to ask that question. He's asking the question because he doesn't know the answer. So we can rule Eric Alvarado out as well. And you also have to ask yourself, well, wait a second, you know, the truth is, it never changes, right? I mean, the truth never changes. What, if this were legitimate, then why are they offering you all these alternative theories? So the defense counsel also made the argument. Well, wait a second. Why didn't a court interpreter come and testify and translate the videos in real time, right? Why didn't they do that? Because the court interpreter is neutral. The state hired the FBI. The state hired a private interpreter. Why would they have done that? Well, there's a very good reason, and the reason, of course, doesn't come from me. The reason doesn't come from the words of the attorney, because what the judge told you, and what the judge told you right before I got up for my first closing argument is, what did he say? The words of the attorneys are not evidence, right? The words of the attorneys are not evidence. The evidence comes from the exhibits and what's said here under oath by the witnesses in the case. So let's fall back to the evidence, right? Let's fall back to the evidence. What is the evidence in this case? Rose Rosario, and I asked her, what is the difference? Tell us the difference between a translator on one hand versus an interpreter on the other. What did she say? She said, listen, there's a large difference, right? A large difference. Translators use documents and recordings. Translators have the luxury of being able to sit down and to sift through recordings and sift through evidence to make sure that they get it right, which is why that they expended so much time on the work that they performed. They have the ability to sit down and listen through it, and as both Norma Campos and Rose Rosario explained, they listened to several sections multiple times, and used, and in fact, I think 50 hours for Norma, 50 plus hours, and 100 plus hours for Rose Rosario. So they have the ability to do that, and that's what they did. Why do they do that? Because they can ensure accuracy, and they can go and re-listen to things, and they can also take into account the context of what is being said, right? Very important. Interpreters don't do that. Interpreters translate in real time. They work in real time, and they don't have the luxury of being able to refer to other parts and being able to ascertain meaning from words in that regard. So bear that in mind. Reasonable doubt. Okay, so let's talk about this for a second. Defense counsel says, well, wait a second, there's all kinds of reasonable doubt in this case. And what did they do? They pointed to two errors, right? Two errors within reports. So remember, the criminal justice system is no different than the areas where you work at, in that people make mistakes, right? People make mistakes. There is no such thing as perfection, right? Just because we haven't presented a perfect case doesn't mean that we haven't proven our case. There is no such thing as perfection, and the criminal justice system is no different. Defense counsel points out, well, wait a second, there is a typo in Dr. O'Neill's report regarding Josiah's age. The OBGYN.
Facts and evidence.
As to this point as well, there's a dispute as to the facts of the case, and ladies and gentlemen, you're the fact finders, and you would resolve the dispute, but I'll overrule the objection and leave that to the jury's determination.
Okay. The OBGYN, Dr. Stossel, said the child was 32 or 33 weeks along. Dr. O'Neill said 36 or 38 weeks along. There was a several week difference. Okay, right? Dr. Stossel is going to be more accurate on that point, meaning that Dr. O'Neill had made a mistake when she had simply gone through those medical records. Does that really amount to reasonable doubt? Right? Does that really amount to reasonable doubt? Does that give you any reason? Does that give you any reason to think that Dr. O'Neill got the cause and the manner of death wrong? Of course not. Was Dr. O'Neill wrong when she said that Tanya died of a head injury, which caused a skull fracture and brain swelling? Was she wrong when she said that Tanya died of two significant, serious sharp force injuries to her neck? No. No. We're talking about a typo in her report, or a mistake in her report. Is that reasonable doubt? Of course not. Of course not. There is no requirement. There is nothing in those jury instructions that the judge read to you. There is nothing in the jury instructions that will go back with you that suggest or even approach this standard of perfection that they're wanting you to employ.
Objection,
There
gentlemen.
is no.
You can approach on that. Any other comment? Of law, there, I'll ask you to not consider what was just said, and I've instructed the prosecutor to restate it consistent with the instructions I've given you. You may proceed.
So the point is that there are always conflicts in evidence in any case. The question is, do they rise to that level of reasonable doubt? And of course, the answer to this is no. Defense counsel also pointed out, well, wait a second, there was another typo in the Rose Rosario's translation on her certificate. She translated the August 24th video, and on her certificate she wrote August 23rd. Does that rise to the level of reasonable doubt? Does that rise to the level of those two typos? That's what you're being asked to consider? That two typos in two separate reports, that's reasonable doubt? If you recall from jury selection, what I asked you to do is to not simply hang your hat on one or two items of evidence. If you recall from jury selection, I asked you to consider all of the evidence, right? Not just to hang your hat on one or two pieces. That's what and that's what we're asking you to do, to make sure that we could render a true and fair verdict based on the law and the reasonable doubt instruction. Remember, the defendant is the only witness in this case who had a motive to kill Tanya and her child. No one else. And remember, frankly, we are not here to play the lottery with the evidence in this case, right? We look at all of this through the lens of reasonable doubt. We know the defendant is the only witness in this case with a motive to kill her. The defendant is the only witness who had an opportunity to kill her, right? He's the only witness who had an opportunity to kill her. The defendant's the only witness who was with her on the night of the murder, and he spoke to her on the phone. And he's the only person who planned out her murder and then executed it based on what we know from the translated transcripts by both Norma Campos and Rose Rosario. Ladies and gentlemen, there is no reasonable doubt in this case. There is no reasonable doubt. All of the evidence, when taken in totality, all of the evidence, when considered by fairly and objectively and through the lens of the reasonable doubt instruction, all of it points to this defendant and this defendant alone as to who killed Tanya Wise and her unborn child. On behalf of Tom Backetall, your state attorney, I thank you for your patience and your service today. Thank you so much.
Thank you, attorneys. Members of the jury, yesterday when I instructed you on the law, I advised you that your verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. I know you cannot read it from this distance, but I want to hold it up and show you the form of the verdict. It's a 2-page verdict form. The verdict form has the case style on top and, of course, is entitled Verdict. It starts out with saying, "We, the jury, find Jose Soto-Escalera as to count 1." So it's a 2-part verdict form. Count 1, page 1. Count 2, page 2. Count 1, select only one of the following 4 options: guilty of first-degree murder as charged in the indictment, or guilty of second-degree murder as a lesser-included offense, or guilty of manslaughter as a lesser-included offense, or not guilty. Then what follows on the first page is what we call an interrogatory in the law, which is a question. And it reads as follows, and it's conditional. If you find the defendant guilty as charged of or guilty of any of the above lesser offenses, you must next determine if any of the following has been proven beyond a reasonable doubt. Check yes if proven beyond a reasonable doubt. Check no if not proven beyond a reasonable doubt. And the question is, during the commission of the offense, the defendant did carry, display, use, threaten to use, or attempt to use any weapon. You would check yes or no. There again, that's conditional on a finding of guilt above. Finding of not guilty obviates the need to answer that question. Page 2, count 2, select only one. Guilty of first-degree murder of an unborn child as charged in the indictment, or guilty of second-degree murder of an unborn child as a lesser-included offense, or guilty of manslaughter of an unborn child as a lesser-included offense, or not guilty. The verdict form concludes with the words, "So say we all," which highlights the unanimous nature of your verdict. There's a place for the foreperson to sign and date the verdict form before bringing the verdict form back into the courtroom for me to receive your verdict. When you come in through the door, I will look to see who's holding this paper to identify them as the foreperson of the jury, which I will instruct you on in just a second. Also, please be advised that if you are the foreperson, you're not required to read or publish the verdict form. That is the job of the clerk. So if you fear public speaking, do not let that dissuade you from being the foreperson, because you will not be required, as in some states, to read the verdict form. So in just a few moments, I'm going to submit the case to you, and I will conclude our jury instructions, as I told you yesterday, with the conclusion of the jury instructions, aptly entitled "Submitting Case to Jury." In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you've reached a verdict. You must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of this case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtrooms. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the court deputy where they will be guarded while you deliberate, if you've not already done so. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. However, please remember that deciding the verdict is exclusively your job, and I cannot participate in that function whatsoever. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know and we will bring you into the courtroom to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. And as I told you yesterday, each of you will get a copy of the full instructions when you go back into the jury room. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So at this time, with the exception of our 4 alternate jurors, the jury is about to proceed to the jury room to consider its verdict. You do not know who those alternates are. I do. So when I mention your names, you are the 4 alternate jurors. You cannot go back into the jury room with the jury at this time. So please remain there. If you have any items in the jury room, the 4 alternates, the bailiffs will get them and bring them into the courtroom for you. And I will address you when the jury goes back into the jury room. So the alternates are in the alternates seated next to each other in the second row. Please remain there. The remainder, who are the jury, please proceed to the jury room. The evidence, the instructions, and the verdict form will follow. Oh, that's fine. Madam Clerk, here's the verdict form. So ladies who are 4 alternate jurors, I have some very important specific instructions for you because the situation we're in now is a little bit complicated. Sometimes we have trials where, for various reasons, our alternates are not excused at this point. You still remain in service. This is one of those situations, and it's conditional. If the jury renders a verdict of first-degree murder, as you've heard when we selected the jury, there would be a second phase of this trial where the jury would decide the sentence. If that occurs, you would participate as alternates for that too. And just as during the trial, if someone were to be unavailable or something would happen, which happens quite a lot, that's why we have alternates, you would take their place. You've heard all of the evidence in this case, and it puts you in a position legally to do that. So, after discussing the matter with the lawyers, we have to prepare for that contingency, and I have to give you instructions to maintain your ability to be jurors on the case. Discussing it with the lawyers, if there is a second phase of this trial, it would begin perhaps on Wednesday, no sooner than Wednesday. It is possible it may be a day after that or so forth, after Wednesday, but no sooner. So I just wanted to give you a time frame for that. So you're not excused at this time. depending on the verdict. If the verdict is anything other than first-degree murder, that would conclude your service on the case, but you're still in play here. Now, from my perspective, you may be able to anticipate what I'm going to say, because I've stated from the beginning of this entire process, back in the jury assembly room, before we even started to select a jury in the case, when I came to address the jurors, and throughout the trial, the most important part of the fair trial is for you to decide the case only on the evidence presented and avoid any contact with anything about this case that comes from any source outside of this official process. So all of the rules that you've been under with regard to not speaking about the case to anyone, or doing any research, or being exposed to media coverage, remain in place, because it could be that next week you're on the panel and that someone else gets excused and you become one of the actual people to decide the sentence in this case. You all understand that. It's very important. So also, if we will be in touch with you, it's very imperative that you have a phone number, a contact number, which you can give to the court deputies on the way out, where the jury clerk can update you on what's going on. And obviously in this situation, normally I tell jurors, if you're curious as far as what happens, even if you're released, they'll give you a phone call and tell you what happens. Here it's imperative that they do that, because it determines whether you're coming back or not. In case the verdict is something other than first-degree murder, though, I do want to take this opportunity to thank you for your time and attention in the case. We're talking about a very large amount of time and commitment. It's no less important to the parties, the lawyers, and myself, the time that you've spent, if the verdict is anything that other than what requires you to return. So on behalf of the United States, the state of Florida, at this time I thank you for your continued service, and if it's your complete service, that as well. At this time, you're free to leave and go about your business, so as long as we have a contact number. But remember, please maintain the sanctity of your mind as far as deciding this case only on the evidence presented. And either we'll see you next week, or at this time, thank you very much. With regard to your notes, we will keep your notes in case you need them if you wind up participating. So if you just leave them there, we'll have them for you. If you need to come back, we will preserve your notes. They will not be destroyed at this time. Thank you very much. And the bailiffs will assist you in leaving the courthouse at this time. That's fine. Oh, for these folks? I'll leave that to the bailiffs. All right, the alternates have all left. I'll leave it to the bailiffs to give them instructions about whether they get their Chick-fil-A lunch. I'm sure you'll do that in the hallway, which is set to arrive at 12:15. The lawyers could check the evidence to go back. Looks like the instructions have gone back. The verdict form there. There's a big pile over there that I don't see anymore. So
No, they're still there.
okay, they are. Okay. This is very important for us to make sure there are no items that did not go into evidence.
So I'm opening a manila envelope.
And that the ones that we don't want to go back don't go, the items that are in evidence don't go back.
Shouldn't there be 200 there?
that we don't want to go back.
Oh, the other one.
Two hard drives go back, one hard drive drive stays.
There's a flash drive here.
I'm gonna stay on the record while we do that.
171,
I'm sorry, Judge, you said stay
Yeah,
on?
I'm gonna stay on the record while it's happening.
This is no.
Okay,
This is,
the SD card.
which was never entered.
Right,
This is the perpetuated testimony, not
Okay.
supposed to go back.
right,
This is a condom that was never entered.
okay.
And then this is the hard drive, which is,
But we're missing two things.
yeah, all the hard drives are supposed to be over here.
Right.
I have
That's
these
right.
two.
169, 170, 183.
This one.
I don't know what this is.
That's 183. It was remarked as court one.
Yeah,
Okay.
yeah.
So this is just a court exhibit because it got marked as
169.
one.
And 170?
Those two go in
Right,
here too.
okay, those two go in. Those don't go back.
No.
Right.
If they want to see those, we have to play them before they're not here.
Those are the two hard drives that are
Correct.
in evidence that are not going back with the jury.
Everything else goes back. Those were the only items that don't go.
All right, so you're good now?
Yes.
We put all the stuff that's not
Gotcha.
supposed to go back in this.
Close it up.
Put it over.
Close it, yeah. Put it over there. and
Just
close it
well, until we give them the evidence.
Yes.
It's
Right.
sitting here for
Right.
the
up. Okay,
judge.
good.
Verdict
Nice.
form over there,
I have 34.
and the instructions are all over there. Okay, bailiff has them.
Now, do you want that cooler to go back there, or you want?
Yeah, that's fine.
I could
Because
take it out
that's
of
the
that-
exhibit, it's marked.
I could take it out of that box. It can come out of that box.
Yeah, it shouldn't, yeah, we don't need to have a box. And then I have also shown defense the clean laptop, and we went over that. No objection to the clean laptop going back. Ms. Minton?
No objection.
Clean laptop is going back for the defendant's review.
Laptop's on there.
All right, want to commend the lawyers for their fine performance, their closing arguments. I think it was excellent arguments on both sides. We'll see what the jury says about the case. The lunch is arriving, I'm told, at 12:15, so in my experience, that means we're going to be here at least till 12:15 because they're going to be waiting for their free lunch, as I would. And so it gives you an idea. Probably won't hear from them until at least 12:45, 1 o'clock if you want to go
Jeff,
in.
do you want to address the penalty phase
Sure.
scheduling and possible issues? Yes.
If that occurs as soon as we can, just to for planning purposes, if there is a verdict of first-degree murder, when you think what we're looking at in that regard.
Judge, this gentleman whom I've asked to come forward is Carlos Fuentes. He is the investigator for the defense team. We have several of Mr. Soto-Escalera's family in Connecticut. We've been trying to communicate with them and corral them for the past few days. Mr. Fuentes is in a better position than I to tell you what the situation is, but there are 7, 8, maybe 9 persons in Bridgeport. They are Mr. Soto-Escalera's family. I believe they are all, virtually all, living with the help of public assistance. I believe that Connecticut provides social workers and other liaison persons to guide them through the use of those systems. They do not have electronics, no laptops, no computers. They are essentially, I went up there and visited with them during the pendency of this case, akin to children who don't really function or are not fully plugged into the 21st century. To get them down here to testify in person, we have in mind that Mr. Fuentes would travel up there, do his best to corral them, usher them through the airport. These are people who don't have their own transportation. They don't know how to work airline tickets online. They would not know how to walk into an airport, up to a kiosk and get themselves a boarding pass printed. They don't know what a boarding pass is. They don't travel, they don't fly. They are a very disconnected sort of group of people, and yet we would like them here to testify. And Mr. Fuentes is going to give you an idea of how long that might take. I think we are suggesting possibly September 30, but I will turn it over to Mr. Fuentes, Judge, if that is acceptable to you.
Yes, although before you do that,
We have some local witnesses who are available before that, and I do believe we can get Mr. Soto-Escalera's Father Concepcion Soto here from Puerto Rico before that date. But it is the Bridgeport witnesses that are a concern to me.
Well, I imagine the investigator's just going to tell me he thinks it's going to take until September 30th to do that.
Right, Your Honor, because they add to that, they're in New Haven, so they're like, there would be 3 hours either to go to the closest airport, which would be LaGuardia, and get them going out of there. So it's not only just the herding and getting them, but to transport them to the nearest airport from the different municipalities that they're in New Haven. I know it's a burden on the court, and this is not something that typically I run into. But these are people who really of little or no means at all, no transportation. And I'd be more than happy to be able to do this, to expedite it. I wish we didn't have to do it. It's not typical. But this is the only way that I know it's going to happen, because for these individuals to get into some type of vehicle anyhow, to get 3 hours to an airport and to get them through LaGuardia, and to get them into a flight back here and settle into a hotel and get them all back here in the morning for court to testify machine gun one after another. I would say safely, September 30th. I mean, they're paraplegic kids they take care of that they got to attend to as well. And that's the situation you're in. If I could do it sooner, I'd be more than happy to oblige the court.
So I mean, the goal would be to start on Wednesday, the 24th. The request is an extra 6 days, but not sure I understand what the need for the additional days are. I mean, I realize it's going to be a difficult haul, but this is Friday. Go up tomorrow, lasso them all up, bring them to an airport, and get them here by early next week. I'm not sure.
They've been on standby, so again, I don't know exactly how they're scheduled with doctors, or again, there's a paraplegic child that needs to be tended to as well. I'll be more than happy to do it as soon as I possibly can make it happen, and I could, inform the court as I go.
Well, I can't play it by ear as a judge, and we have to have a date certain to do this. From my perspective, I'll let the state ask you questions too, obviously, but I want to give the defense a fair opportunity to do that. I'm not convinced that if we do the penalty phase Wednesday, that's not a fair opportunity given the weekend and then Monday and Tuesday to effectuate that. Cost is not an issue. I'll authorize whatever it takes.
I believe those costs have already been authorized.
Right, it's already been authorized, so I'm sympathetic to the logistics, but I mean, it's of grave inconvenience to the judiciary to postpone it in that regard.
Well, can we give a status on Monday as to that matter? How far I've gone with it, and how many reeled up, and how many.
The other thing is, I'm not convinced. We could always do a status. I want to be fair, but if I pose the question this way, if it can't be done by Wednesday, why would we think that it could be done at a later time to do that? You follow that?
I don't know what their schedules or what their
Right.
lives are at. We've been waiting for this. I mean, they know the case was going on,
Yeah.
but now we're ready. This is D-Day. Now it's time to call, hey, let's go. How quick can you be ready to go?
Also, as a backup, I realize this is a capital situation, but if there's been a conversation about if you were to make your best effort to get them here in person, but if that falls apart, I'm also open to, we could Zoom them if someone is up there. I do that all the time, and we could do that just as well. They would appear via Zoom to do that. I'm just throwing that. I think that the state would, I think we'd have to have an agreement. I think the defense is inclined to agree with that, but I have no problem setting that up. I mean, I didn't Zoom this trial because I don't Zoom trials of this, but for the penalty phase, but absolutely have the ability
Well,
to
if
do that.
Investigator Fuentes is up there with them, and that we can't do it the way we would like and bring them here timely in person, we could conceivably do that. These people wouldn't be able to arrange that themselves, but we would need to build in a little bit of extra time. I was hoping to have them here Monday, and Mr. Richardson would have a chance to talk to them as he has indicated he wants to do and has a right to do on Monday or Tuesday if need be.
Mm-hmm.
But we will need to build in some time if they're going to Zoom for Mr. Richardson and or Mr. Cormier to do a deposition of them.
And to be clear, we've tried this before. We tried to coordinate a Zoom depositions for them back in, I want to say May or June.
Right.
And it never materialized.
I think the
They had no
difference
on-site
was,
assistance as what they have.
exactly, that was, and given their unsophisticated nature, that was asking them to have a phone or do something on their own. If he's the master of ceremonies, I was thinking of the most
Yeah.
euphemistic term for this scenario without denigrating the people up there. We could literally do it on his cell phone as if he's with them. We do that all the time, and the quality of that is pretty fantastic, given where we are with the Zoom. So if the lawyers are amenable to that, and you could do your depositions, that way too. But the difference is he would fly up there and get with them to facilitate it. And that for them is the easiest and least extremely convenient.
And we would need the mitigation expert up there with me as well, because they live in different municipalities around town. So
Right.
my plan was, and for the depot, the same as get one centralized place.
Fine, there's enough money allocated
Yeah.
to achieve that. That's not a problem.
I think that should be, if everyone's okay with Zoom, that's.
I'm okay with it, sure. I just want to make sure I get an opportunity to speak to them through deposition before they actually testify.
Right.
That's my only request.
And as we broached this subject once before, in my experience in this field of litigation is that the depots are pretty finite. They're going to say what they're going to say, and now you know what they're going to say.
Yes, the commentary will be as expected, I would say.
Right, right. So I think that should be the game plan. However you want to logistically facilitate that, that's fine with me. But I will turn on the Zoom. They'll appear on the screen there. The lead attorneys know because we do this all the time. But for you, that's the easiest, rather than getting them to, they don't have to leave the person that you mentioned, the special needs person, and that much preferred.
Okay, if I understand, no adjustment in the present schedule. If we can get the witnesses here in person, that will be fine. If we cannot, the court would accommodate a video appearance.
Absolutely,
Possible.
absolutely. So we would aim for Wednesday if the verdict is a first degree murder, yeah.
And assuming there is sufficient time and we can get the depositions that the state wants concluded in time. All right.
I hearken back to other cases I've done with this exact same problem, and before the pandemic, in the advent of Zoom, or Zoom taking over the world, people had to go to like a copy shop and had to have a special camera, and it was much more of a nightmare because of the Zoom, the blessing that Zoom is. If there's any way that this is going to get done, the easiest way most likely for it to happen would be for you or the other person in the mitigation specialist to be with these people, either if they're in one place or different places with a regular cell phone. The quality would be excellent, and the state would have the ability to do the deposition and get it all done. Yeah.
Well, the witnesses do, of course, have a pre-existing relationship with Mr. Fuentes and Ms. Schwartz, our mitigation people. So.
Great. Okay. Very good. So that's a good plan. I think we all benefited by having that discussion. Let's aim for the 24th, and also it's good on our end too, because if that can't be done that way, I think there's no other way it would have been possible. I mean, if we can't pull it off by Zoom, it's not possible. All right, very good. And the attorneys, of course, have my Zoom number that I use all the time for that purpose. Very good. Thank you. All right, so we'll be in recess awaiting a verdict or a question.
Could I have a copy of the verdict form?
Let's see. I had a few copies. I'll print you out one, yeah. We'll go off the record.